Good morning, Adele.
Good morning, Owen. How are you?
I'm very well. How are you?
I'm also very well, thank you.
Any announcements from your side?
No, not today.
Okay. So, there's nothing from my side either. But if something pops up, I'll send you a WhatsApp or something like that. Yeah?
Sure. Thank you, Owen.
Okay. Okay, Adele. Thanks so much. Morning, students. Um, Let me check. Um, oh, Terence is back. Terence wasn't here last week. Morning, Alzette. Morning, Amile. Louise is here. Perez is here. Good morning, guys. Is there anyone new on the chat this morning? Anyone new on the chat this morning? Morning, Angela. Um, I don't notice anyone new. Okay, students. Let me just. Are there any questions for me while I access my notes? Any questions for me while I access my notes? Um, I know Angela. I don't see Michelle online, but Angela, I've confirmed a booking with you for consultation next week. Ne? We've emailed each other. So, Angela,
Good morning, Advocate.
yes, I'm consulting with you next week. Let me just see the time. What time am I consulting with you?
You
Tuesday.
said between 4 and 5, yes.
Yes, and that's on Tuesday.
Yes, sir.
Okay. I will send you the link on Tuesday morning. Okay.
Thank you, Advocate.
Okay. So you get your queries and things ready and stuff like that, and then we can take it from there. You can even email to me on Tuesday morning. Okay.
I'll do so. Thank you.
Okay. And then okay. Are there any other questions before I start? You know you must morning Abinwe. Um you know you must put your student numbers in the chat. So just give me a second to access my notes and then we can start. Okay. Okay, I think we have to start. I'm speaking under correction now. Um, I think we have to start with this module with revision today. Um, so students, let us in our work in our notes. can start on page 5. Okay, we start with learning unit 1, law and life. Okay, if all of you are ready, I will start. So paragraph 1.1. Okay. You must be mindful that as someone partaking in the activities of society, okay, law impacts on almost everything you do. Okay, meaning that if we look at what a legal norm is, okay, a norm is a standard of human conduct or a rule of human behavior. So this standard, okay, will regulate, okay, this legal norm, okay, this standard will regulate human conduct within society. Okay, students? So if we go to page 7, okay? If we go to page 7, it tells us in paragraph 2, it tells us in paragraph 2 that when we use the words law in our everyday speech, students, these aspects I'm reading to you now, reading and explaining, I hope you're sitting with a highlighter or something just to highlight and underline those most important aspects for me. Okay? So it tells us that when we use the words law in our everyday speech, okay, we mean different things and different times. We speak, for example, of the law of the land. We speak
Good
of,
morning, Advocate. Good morning, it's Terence here.
yes, students,
What page are you on the study guide? Which page are you on the study guide?
I'm on page 7.
7.
Yeah.
Is that is that a different course? Is that for introduction to law, or is this law of persons?
I'm, oh, Terence. We're supposed to do law of persons today. Yeah. And I started with ILW, which is actually my Monday module. Okay, why didn't anyone tell me about it earlier?
I was about to say advocate. I was confused.
Okay. Okay, apologies about that. Listen, give me a minute to access the law of persons study guide, then we go over to law of persons. Okay, apologies about that, students. Let me just get the law of persons notes. 1 second. Thank you for that, Terence. Law of persons. Okay. Um, Guys, I'm just trying to access the notes quickly. Give me a second. Okay, got it. Okay. Um, okay, law of persons. We're going to go to page. I've got, I think it's the fourth edition of the textbook. Yes. Okay. I want us to start with, we're going to look at the definition of the law of persons, and then we work from there. Okay. Now, your test will probably be MCQ. Okay, I don't know the format of the test, but it's very important for you guys to know definitions verbatim. Okay, so I am on page 1 by the introduction paragraphs of the law of persons, and it tells us that, loosely defined, firstly, the law of persons is part of the branch of private law, okay, which determines which beings are legal subjects. Okay. Now, this might sound like a very simple question, okay? But what is a being, students? What is a being? Anyone? Terence, what is a being?
I would say every human that is born is a being or a human being.
Okay. What about a dog and an ape? They are born.
They're animals, they're not beings.
Okay. What separates a human from an animal?
Is the ability to reason.
Okay, very good. Very good, Terence. Okay, so very, very importantly, students, this branch of private law, firstly, okay, primarily determines which beings are legal subjects. Okay, that's the first part of it. Secondly, when legal personality begins. Thirdly, when legal personality ends. Fourthly, what legal status involves. Fifthly, and what effect the various factors, okay, will have on a person's legal status. Okay, so those are all the aspects of the law of persons. Okay, now if we look at paragraph 1.2, okay, law and rights, it tells us the law can be viewed from different angles. Okay? On the one hand, we know already, okay? We know already it's a system of norms, of conduct or rules, okay? Put in place by competent bodies, okay? So our norms and rules are put in place by who? Student, okay? Who determines the norms of our conduct in South Africa? Who determines our legal rules, students? I'm on page 1 still.
Well, that would be the state makes the rule, or the government makes the rules, but the rules are, they're made by the people, actually, and the people abide by the rules. But essentially, from an official or legal perspective, they're made by the government.
Terence, how much would I give you for that answer?
I don't know, probably 0.
0. I'll give you a fat round 0. So please try again. I'm asking you, listen to the question carefully.
Yeah.
Okay. Our rules or our system of norms, okay, it's regulated by a specific body. Okay. Your answer to me was government. That is very broad. Okay. So who determines our rules?
The legislature.
Thank you.
Okay.
Thank you.
Sorry. I need to
Okay.
get that right. Yeah.
Okay. So be very specific about your answer, because in the MCQ, if you get a question like this, okay, your options is going to be government. Okay. And you're going to remember, I had this conversation in class, and you're going to know it's wrong. Okay. So how is it that the legislature is responsible for our set of legal norms? How is it? What principle determines that? What principle determines that? Guys, come. What
Sorry,
principle?
Advocate, can you please rephrase your question? I'm not sure I understand it.
Okay. We've now determined by Terence's answer that the legislature is responsible for our set of legal rules that we have to abide by. Okay? So, my question to you is, why is it the legislature's responsibility? What principle determines that? Thank you. Here's someone that gave the answer. Can we check the chat function, please? We see who this person is. Shunaini Purusha. Okay? The doctrine of separation of powers. Okay? It's regulated by the doctrine of separation of powers. And what is the purpose of this doctrine, people? What is the purpose of this doctrine? What is the purpose of this doctrine? Anyone? Terence? Where's Perez? Why are you so quiet today, Perez? What, Terence? What is the purpose of this doctrine?
It's to keep the 3 tiers of government independent and separate in determining the rules, the legal rules.
Okay, but what is the most important function? Why do we have this doctrine of separation of powers? Why? The answer is very simple, Terence. The answer is very simple. Why? Think about it quickly.
To make sure that everybody obeys the rule. So it's
No. Okay, let us see the chat function. Thank you, Amile. Okay, Terence, let's look at Amile's answer. To ensure that there's no abuse of the power that is wielded by the state. Okay, to ensure that we as legal subjects are protected from the abuse of state power. Okay, who can give me an example of that? Who can give me an example of that? How are our laws in place so that the individual is protected against the abuse of state power? Can someone give me an example, please? Can someone give me an example, please?
Discrimination against minorities.
No. Give me a practical example.
The government can forcibly remove people from their land without compensation.
No. Come, I give you guys a practical example. Those of you who have a copy of the Constitution, a simple provision is our Section 35 rights. Okay, the rights of arrested and detained persons. Okay, so the law provides, Section 35, that if you are arrested, okay, you have the right to remain silent. No one can force you to make an admission or to speak. You have the right to remain silent. Okay. Another Section 35 right is the presumption of innocence. Okay. If you are arrested and charged for a crime, that presumption automatically kicks in. And that presumption says that you are presumed to be innocent until proven guilty by a competent court. Okay, so these are examples of how the doctrine of separation of powers operate. Okay, to put legislative measures in place to protect the individual against the abuse of state power. Does that make sense to you guys? Does that make sense to you guys? Louise, very good. We have certain bodies like the public protector, and the public protector is what? A Chapter 9 institution. And the purpose of Chapter 9 institutions is to protect, preserve, and promote our constitutional democracy. Okay, Delani, what is Delani saying? To ensure that no much power is yes, Delani, I agree with you. To protect the public from the abuse of the state, yes. Okay. Terence and the rest of you, does that make sense to you guys?
Yeah, thank you. Yeah.
Okay, let's continue. Are there any other questions before I continue? So guys, as I'm doing revision, as I'm speaking about these these are things you must take note of so you can start thinking out of the box. Okay, these are the answers and the responses that are going to give you A's. Okay, I'm used to my students getting A's. Okay, let's continue. So firstly, we spoke about the competent body who is there to regulate, to put these system of norms in place. And then we have relations between members of the community, okay, that must be regulated in a just and peaceful manner. Okay. In this sense, we are concerned with law in an objective sense. So, when we speak of law in an objective sense, what interpretation of the law are we speaking of? A wide or a narrow interpretation? Are we speaking of a wide or a narrow interpretation? Students, come. If you look at the second part, okay, under paragraph 1.2, when we look at to regulate the relations between members of the community in a peaceful and just manner. Okay, it tells us in this sense we are concerned with the law in an objective sense. What interpretation of the law are we looking at there? Come, guys. Thank you, Louise. We are looking at the wide or the broad interpretation. Okay, we're looking at the wide or the broad interpretation, and which body of our law are we referring to here? Which body of our law are we referring to here? Anyone?
The judicial.
No, Terence. Which body of our law are we referring to here? We're referring to our body of private law. Okay, because it's that body of private law that is used to regulate the relationship between members of society. Okay, let me give you an example, and I've spoken about this before. We take the employer-employee relationship, okay, and what regulates that relationship? An employment contract. Okay, so an employment contract will regulate the employer-employee relationship. And what is the outcome of that? The outcome of that is that the relationship between those parties are in a peaceful and just manner. Does it make sense, people? Does it make sense?
Yeah, sure.
Okay, let's continue. Now, let's look at the legal relationship in a subjective sense. Okay, let's look at it in a subjective sense. Okay, and it tells us here we are concerned, okay, sorry, but rather the network of legal relationships amongst legal subjects. Okay, yeah, we are concerned with rights, okay, or law in a subjective sense. Let's look at the example. If a person owns a motor vehicle, he or she has a right to that motor vehicle, which all other legal subjects must respect. And if a person concludes a contract with somebody else, okay, that person has a right to fulfillment of contractual obligations which one party to the contract must meet. Okay? It goes on to tell us that thus these rights concern a dual relationship. Okay? Firstly, we look at the legal relationship between the bearer of a right and other legal subjects. Okay? This is the subject relationship, meaning the content of this relationship is a right and a corresponding obligation. So, the bearer of the right is entitled to the right against the other legal subjects who are obliged to respect it. Okay? Then we look at the legal relationship between the bearer of the right and the object of the right, meaning this is the subject-object relationship, meaning one can speak of a right only if the right relates to an object. For example, one has a right to one's motor vehicle. Okay, it would be meaningless to have a right against others if that right did not pertain to an object or another. Okay, so I want you to go through paragraph 1.3 on your own. Okay, those the rights in relation to various things, and here we're looking at corporeals, we're looking at performance, we're looking at personality property, we're looking at intellectual property. Okay, then quickly through paragraph 1.4. We know in South African law we have two distinctive legal subjects. Okay, the first legal subject, and this is where we're going to do lots of work in the law of persons. The first legal subject is our natural person, okay? Meaning all human beings are recognized as legal subjects, regardless of, for example, certain impediments, such as their age or intellectual or physical ability. Meaning, therefore, every human being, very, very importantly, students, this is fundamental to the law of persons. Okay? It tells us every human being can have rights, duties, and capacities. Okay? Although the content, very, very importantly, although the content of these rights, duties, and capacities may vary depending on certain factors, such as mental capacity and age. Okay? So, if we look back in history, students, and this is what you must be mindful of, okay? We need to know our history in order to appreciate our future. Okay, so if you look at this very, very important paragraph, it tells us in the past, some humans were not recognized as legal subjects. And it gives us a very good example. For example, slaves at the Cape, and now we're going back to 1652. Okay, when the Dutch with Jan van Riebeeck and his 3 ships came to the Cape. Okay, it tells us that, for example, slaves at the Cape were legal objects until slavery was abolished in 1834. Okay, in Roman and Roman Dutch law, very, very important. Okay, children who were born severely deformed, okay, were so-called monster. Okay, that is, we use it as the word monster, but that is where the term comes from. Okay, and these children, malformed children, were not regarded as legal subjects either. Okay, meaning They could be killed after permission has been granted by a magistrate. Okay? But this is our history. These rules do not apply in South African law anymore. But this is what our legal system was before. Remember, our legal system today is based on what? What is our legal system based on today, students? What is our legal system based on today? Anyone? Louise, thank you, Paris. We have a constitution, okay? And now I want to see who can think out of the box. What is so distinct about the South African Constitution? What makes the South African Constitution different and distinctive? What makes the South African Constitution different? Anyone? What makes the South African Constitution different? That is, what makes the South African Constitution different? Some people? What makes the South African Constitution different? Louise, you're on the right track, but you're not telling me. Very good, Delani, the Bill of Rights. Okay? Our Bill of Rights. Okay? It's human rights based. Okay? Our Constitution is human rights based. Okay? Very good, Delani. Okay, let's continue to 1.4.2. Okay, the next type of legal subject is the juristic or artificial person. Okay, so the human being or natural person we know now is not the only legal subject recognized by South African law. Okay, the demands of legal order necessitate, okay, that legal personality also be conferred or bestowed on certain associations of natural persons. Okay? And you can read the rest through on the next page. Okay? Let's go to paragraph 1.5. All of us, we go to paragraph 1.5 quickly, and we're going to look at the law of persons, the Constitution, and transformative constitutionalism. Any questions for me so far? Any questions for me so far? No questions. Let's go to paragraph 1.5. Okay. So, very, very importantly, you must know this in your sleep by now. Our South African Constitution is the supreme law of our country. Okay. Meaning that all law and public power derive their force from the Constitution. And then also very, very importantly, students, any law or conduct which is inconsistent with our Constitution, okay, can be declared invalid. Okay, it can be declared invalid. Okay, so very, very importantly, students, our Bill of Rights, okay, and constitutional values are set out in section 1 of the Constitution. Okay, it's set out in section 1 of our Constitution. Okay, those of you who have copies of the Constitution with you, those of you who have copies of the Constitution with you, I just want you to go to section 1 of our Constitution quickly. Okay, so if you go to section 1, I need you to be very mindful of this. Section 1 tells us the following. Okay, I'm going to repeat this. It tells us the Bill of Rights, which tells us our Constitution is human rights based, and the constitutional values are set out in section 1 of the Constitution. Okay, meaning these are key provisions in what? In testing law and conduct for constitutionality. Okay, and it goes on to say these provisions have been the foundation of statutory and judicial development, okay, of several aspects of the law of persons, okay, including the extensive revision of the legal position of unmarried fathers in terms of the Children's Act. Very, very important also, the extension of the duty of support to the paternal grandparents of a child born of unmarried parents. That's in terms of Peterson versus the maintenance officer. Also, the enactment of provisions of the Children's Act, which supplements the rights that the Constitution confers on every child. Okay, Section 28(2) of the Constitution is an example of that. The protection afforded in Malcolm versus Premier of the Western Cape to minors whose claims would have prescribed as a result of lowering of age of majority. Okay, and the protection and special rights afforded to mentally ill persons in terms of the Mental Health Care Act. Okay, and so on and so on. So I just want to read to you the founding provisions in chapter 1. Okay, okay. So our founding provisions are chapter 1. Okay, these are sections 1 to 6. Okay, I'm just going to read chapter 1 to you. The Republic of South Africa is one sovereign democratic state founded on the following values. Okay, 1A, human dignity, the achievement of equality, and the advancement of human rights and freedom. 1B, non-racialism and non-sexism. 1C, very, very important, highlight that one. Supremacy of the Constitution and the rule of law. Okay. And then section 2 of the Constitution, supremacy of the Constitution, is a provision on its own, which tells us the Constitution is supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. Okay. Section 3 speaks of citizenship. Section 4, the national anthem. Section 5, the national flag. And Section 6, languages. Those are the founding provisions. Okay? So please familiarize yourself with that and how our constitution has been transformed, okay, very, very importantly, in terms of legislative developments, and examples have been given to you, the Children's Act, okay, provisions in terms of the Maintenance Act, where the Maintenance Act has been amended. We're looking at the Mental Health Act, and then we're looking at case law such as S versus Makwanyana, which abolished the death sentence. We're looking at Christian Lawyers Association of South Africa versus Minister of Health, where the provisions of the Choice of Termination of Pregnancy Act, which allow a minor independently to consent to the termination of his or her pregnancy, were challenged. Okay, so please go read through that so that you can answer questions on the transformative nature of our constitution. Okay, any questions, students? Any questions? Any questions? Okay, Angela says no questions. Let me just see who else here is. Okay, there's no question so far. Let's go on to page 7. Let's look at the beginning of legal personality. Very, very importantly, students, very, very importantly, it tells us in paragraph 2.1, okay, a natural person, okay, a natural person's legal personality firstly begins at birth, okay, but certain requirements must be met, okay. Two requirements must be met. Firstly, the birth must be fully completed. That is, the body of the mother and the body of the child must be completely separated. Meaning, for birth to be completed, it is not required that the umbilical cord be severed, but there must be complete separation from mother or child, from mother and child. Okay. Requirement number 2, the child must live after separation. There must be life, even if only for a short period. Okay. It tells us further, a stillborn child or a child who dies during birth, therefore, does not acquire legal personality. Okay? In our law,
So, sorry, Advocate Clenons, when they talk about a short period, just a way of interest, how long are they talking about there? Is it a matter of hours or
it's a
days?
matter of minutes. It's
Minutes,
a matter of
okay.
minutes, yes, as
Right.
long as both the requirements were met. Okay?
Okay.
Birth must have been completed, and in terms of number two, there must have been activity of the lungs and the heart. So the child must have breathed independently. There must have been independent breath. As long as it's two breaths or one breath, there must have been life. Okay?
Okay, thanks.
Okay. So as we said, a stillborn child or a child who dies during birth does not acquire legal personality. Okay? Very, very importantly, in our law, although not authoritatively decided, okay, how life of the birth must be proved, okay, normally evidence that there was breath is accepted. However, any medical evidence by which life may be proved should be admissible when the issue of whether a child was born alive is to be decided for determining whether the child has obtained legal personality. Okay? On page 8, the procedural aspects you must go through on your own. So the registration of birth, please go through on your own. Okay. Very, very importantly, if you look at page 9, sorry, I'm on page 8, the last paragraph. It tells us that no birth may be registered unless a forename, that is the name or individual name and surname, has been assigned to a child. Okay? So a child must have a name and surname. Okay, that's in terms of the Constitution. It's a constitutional right. Okay, so in terms of Section 28(1)(a) of the Constitution, every child has the right to a name. Okay. Um, so just go read all of that quickly. We go to paragraph 2.3. Okay, that's page 12. Paragraph 2.3 on page 12. The interest of the unborn child. The interest of the unborn child. Okay. Any questions for me so far? Any questions for me so far? Okay, Terence, you just need to switch off your mic, okay? Okay, if there's no questions, we're on page 12, paragraph 2.3, the interest of the unborn child. Okay, and here we're looking at the Nascaturas fiction. Okay. So firstly, you need to be mindful of our general rule. Okay, and our general rule is a natural person's legal personality begins at birth. Okay, meaning, therefore, the unborn are not regarded as legal subjects and cannot have rights, duties, and capacities. Okay, but what happens? Our law now protects potential interests of the unborn by employing the Nascaturas fiction. Okay? By employing the Nascaturas fiction. Okay? So, in terms of this fiction, a Nascaturas, the Nascaturas is the unborn child, is regarded as having been born at the time of his or her conception whenever it is to his or her advantage. Okay? Meaning the fiction operates as follows. If it appears that the Nascaturas would have had a certain claim or rights, had he already been born, the legal position is kept in abeyance until the Nascaturas is born and acquires legal personality. Okay? So for the Nascaturas fiction to come into operation, okay, two requirements must be met. Okay? Firstly, the Nascaturas must have been conceived at the time that the benefit would have accrued. And secondly, the Nascaturas must subsequently be born alive. Okay? If not born alive, okay, the Nascaturas is considered as never even having been conceived. Okay? Any questions? Any questions? I'm on page 13. Very, very importantly, for the Nascaturas fiction to operate, okay, it must be to the advantage of the Nascaturas. Okay? Meaning a third person may benefit from the application of the Nascaturas fiction if such benefit is a natural consequence of the application of the fiction in favor of the Nascaturas. But the fiction may not be applied solely to the benefit of a third person. And let's look at an example. Take the example of a particular person's death. Okay? If the child dies shortly after birth, the Nascaturas fiction will not be applied because only persons who will benefit from the application of the fiction is the child's intestate heirs and not the child personally. Okay? Let's look at fields of application. Okay? At common law, the nasciturus fiction was mainly applied to the field of succession, okay, was applied to intestate succession as well as testate succession, okay. It was applied on page 15 to maintenance of the birth, and there the Shields versus Shields case is important because it tells us in Shields versus Shields, the divorcing parents of an unborn child entered into a settlement agreement, okay, which provided that the child's father would not be responsible for the child's maintenance. The court regarded this provision as contra bonis mores because the mother cannot decide to waive the rights of her unborn child to the right to claim maintenance. Okay. The next field is a dependence action for loss of support. And here our case law is CRISM versus East Rand Proprietary Mines Limited, where it was held that a child whose father was killed prior to his or her death as a result of someone else's delict has a dependence action for damages for loss of support. Okay, a very, very important case if we look at prenatal injury was Santam versus Pension. Okay, this is a very important case and it's a case you should know. So those of you who want to send me case summaries on pension, please do so that I can go through these case summaries and give you comment on it. Okay, so you can email the case summaries to me and we will have a look at it. Any questions so far? Any questions so far?
If you could, Thanos, can you please explain the nasciturus, well, just surrounding the nasciturus fiction and the nasciturus rule, please.
Okay. Let me just get to the next. You, Terence, do you know what the fiction is?
Yes, I know what the fiction is.
Explain to me what the fiction is.
The fiction is applies when the child is being conceived, but not yet born, and if a situation arises where the child is to benefit, is to his or her benefit, then the nasciturus fiction would apply in that case, which would yeah. So the nasciturus fiction is when the child is actually conceived but not yet born, and when it's to their benefit, right? The nasciturus rule is that legal personality starts at conception and not at birth. So where the nasciturus fiction is that means that the even though they're not born, this is why my confusion between the rule and the fiction is that they seem contradictory, actually, to be honest.
Okay, tell me again what you understand under the rule. The rule tells you that whenever there's a benefit, okay, the rule tells us that
the unborn child is given a legal
personality at
conception.
At conception, yes. Okay. Now, the reason why the fiction is used in terms of the rule, okay, is that our law does not regard legal personality at conception. Okay, and the guiding factor is that there must be an advantage. Okay, now the problem that comes with that is, what if the advantage occurred before conception? Okay, then the nascituras can not benefit. Okay, but in terms of the nascituras fiction, okay, as soon as there is a benefit, as soon as there's a benefit, the fiction kicks in, and that benefit is kept in abeyance until two very important requirements are met. And the requirement is, one of the requirements is that the child must have been born alive. Okay, I hope that makes sense. If it
Yeah.
doesn't make sense to you, then the two of us will discuss this during a one-on-one session. Okay.
Okay. Thank you.
Okay. Any other questions? Where's Angela and Perez? You guys have no questions for me today? Okay, so lastly, I'm telling you that the pension case is very important. So please have a look at that. Angela, no questions. Amelia, no questions. And Perez, no questions. Then the last aspect I'm quickly going to look at before I conclude. I want you to have a look at paragraph G on page 20. Okay, familiarize yourself with the aspect of termination of pregnancy. Okay, all those periods in terms of the gestation period, okay, especially in terms of the first 12 weeks and so on. Okay, so termination of pregnancy is important, and that stretches from page 20 right up until till the beginning of page 25. What is important is on page 23, paragraph 2, when there is substantial risk that the fetus will suffer from severe physical or mental abnormality. Okay, go also. So, Terence, I want you again to go through the rule on page 26 of the book. If it doesn't make sense to you, the two of us will have a consultation on it. And then lastly, we look at the end of legal personality. Okay? And it tells us on page 27, paragraph 2.4, A person's legal personality is terminated by death. Therefore, dead people have neither rights nor obligations. Okay? But the law protects the deceased body and regulates its disposal. Okay? Okay? Um, once you are dead, your estate must be rounded up. Okay? And very, very importantly, our next discussion will be on proof of death and presumption of death. So very, very importantly, in private law, proof of death is important for two reasons. Once death has been proved, the deceased estate may be administered and distributed. That's the first aspect. And secondly, the surviving spouse of a civil union partner or a civil marriage may enter into a new marriage or a new civil union. Very, very importantly, the usual way to prove a person's death is by means of presenting a death certificate issued by a medical practitioner. So a death certificate is regarded as prima facie proof of death. Okay. If death was due to natural causes, the certificate indicates the cause of death. If death was due to or suspected to have been on in terms of unnatural causes, an inquest will be held. In such an event, the medical practitioner must note the cause of death. Okay, what we are going to speak on next week is the presumption of death. There are two procedures regulating the presumption of death. The first one is the common law procedure, and the second one is the statutory procedure. We will speak on those aspects next week. Are there any questions for me before I conclude? Okay. If there's no questions, I'm going to conclude with the following. Um, I'm going to conclude with the following. Some of you, I know it's Amos Koopman, Michelle Forbes, um, there's some other students, you have submitted written work to me. Your feedback you will either get on Monday or Tuesday. Remember, I said I'll be out of action until yesterday, the 13th of November. So I have more time now. So I will look at those written work and I will submit feedback by Monday or Tuesday. Um, I missed the skills class. Okay, in next week I'll have a makeup session. So our makeup session for the law of skills, which I missed this week, will be on Wednesday at 5:30. Okay, Adele will just give you a reminder of that, students. So before I go, are there any questions for me? Any questions before I go?
Hi, Advocate.
And
Angela
Angela,
here. Yes, sir.
yes.
Can you please give us a revision outline for law of persons, like you did with the introduction to law?
Okay.
I see on
Let
one of
me,
the IWL revision classes falls on a Saturday,
uh,
which is in contradiction with the PVL sessions.
which is?
So you gave us an outline that on the 28th of, yes, on the 28th, we're going to have a possible 3-hour session
Yes, but
covering 8 to 12.
I will have PVL first.
Okay,
Okay. After that, I will have ILW. Okay, I'll have two sessions of an hour and a half each. I'm going to do the revision outline for all three of the modules, and you guys will have it by Wednesday for the latest. Okay, I'm going
okay,
to submit it to Unisa and Adele Blacker, and they will distribute it to you guys, or they will put it on the group. Okay,
okay.
so that you will have by Wednesday for the latest.
All right, thank you.
Okay, any other questions? So if there's no questions, students, study well, and we will speak to each other on Monday again. Have a good Saturday, students. Good morning.